Thank you, Dr. Ramana, for the kind words. Good afternoon, Justice Sikri, who was one world global acclaim as a great international arbitrator, and my friend Mr. Chandyok, and other distinguished panelists who have gathered here for this legal era summit. As a draftsman of this Insolvency and Bankruptcy Code, it's my duty to defend the code. It has been very rarely a draftsman will get the chance of defending his product, and I am unusually blessed with these opportunities here. Let me first start with the opening remarks about how this bankruptcy code, insolvency and bankruptcy code, is a very important legislation, and how it is going to take India forward as a great global restructuring hub. The Insolvency and Bankruptcy Code is a jewel in the Indian statute book and is a historical law reform legislation undertaken by the government of India. We all know that till the enactment of the Insolvency and Bankruptcy Code, there is no systematic and continuous law reform and based on empirical and social legal research reflecting what some jurists English called as the living law of the people. The Insolvency and Bankruptcy Code is bound to change its trend by introducing a new wave of legal reform which uses big data, data analytics, artificial intelligence, and other market indicators that extensively keeps the law in tune with the current economic and social realities. Now, I'm fond of recollecting in my lectures about the relationship between law and social change. It is in the book of Wolfgang Friedman, Law in a Changing Society. Friedman says the controversy between the law, there are those who believe law should essentially follow and not lead, and it should do so clearly formulated social sentiment, and those who believe that law should be a determined agent in the creation of new social norms is one of the recurring themes in the history of legal thought. Now, this IBC resurrects this age old controversy with a sharper focus on the relationship between law and economics. Law and economics always are closely intermixed and intertwined because, after all, law is an epiphenomenon based upon the superstructure. It is a superstructure built upon the economic substratum. The Insolvency and Bankruptcy Code, all of us are aware, is a piece of economic legislation and is a result of government's response to meet the challenges faced by the country in a fast-paced globalized economy. Before the IBC, the Indian legal framework lacked a robust and comprehensive insolvency and bankruptcy regime for many years. The code represents the current market realities in the financial sector and is supplemented by a very rich ecosystem which enables policymakers and legal researchers to monitor the effectiveness and the implementation of the code, which other acts of parliament lacks. I will say that with a great amount of confidence because I have been a legislative secretary and I know the statute book thoroughly. No other law has so much of support system, and I'll tell you what are the merits in this kind of ecosystem. As provisions of the code evolved and has been subject to many judicial interpretations, yielding a rich body of bankruptcy jurisprudence, which speaks volumes for the vitality of the code. There have been criticisms about the functioning of the code and casting doubts upon the very existence of the code itself. There have been a lot of media publicities. But what concerns us here is a recent report of the committee, Standing Committee's report. The report of the Standing Committee on Finance 2020-21 submitted in August on the implementation of Insolvency and Bankruptcy Code, pitfalls and solutions in its 32nd report, headed by former Minister Jayant Sarno. Let me briefly recapitulate the recommendations of the committee. The report states that the view that the actual operationalization of the amendment made so far may have altered and even digressed from the basic design of the statute and given a different orientation to the code not originally envisioned. The committee also felt that the design and implementation of the code as it has evolved needs to be revisited, particularly in the light of its original aims and subject, and therefore need a thorough evaluation of the extent of fulfillment of these aims and objects in the course of implementation of code over the years. Now, the committee also recommended that an institution of resolution professionals may be established to oversee and regulate the functioning of resolution professionals so that there are appropriate standards and fair regulation. And it also suggested the NCLTs and NCLATs should be completely digitize the records and operations with provisions for virtual hearings to get through the backlog and deal with pending cases swiftly. Thirdly, it suggested appraisal study on the performance of NCLTs with granular data on IBC cases and its impact on the debt portfolio or overall credit markets in India should be conducted and presented to Parliament and published in public domain annually, which will benefit researchers and analysts in this regard. And lastly, an MOU should be signed by the Ministry of Corporate Affairs with the leading business schools and law universities to associate them academically in this exercise and benchmarking the outcomes against the rest of the world. Then all data which should be available should be in a machine readable format, and there should be a broader built-in consultation mechanism and an ecosystem for regular feedback on the performance of NCLTs. Now, before we try to address the shortcomings pointed out by the committee, and let us look at the opportunities and challenges presented by the code, which, if fully capitalized, will facilitate the emergence of India as a major restructuring hub of Asia, which is the theme of this summit. A brief overview of the innovations in technology and its implications on IBC and law reform in general will enable us to understand the new trend set in motion by the government by enactment of the IBC and the series of measures followed up by the government for its effective implementation as part of the larger law reform movement. The code is futuristic in design and can accommodate fast-changing technological developments which have a lightening impact on the financial markets. Digital technology and communication networks have made it possible for the judiciary to migrate to the digital environment and conduct online trial and proceedings. Teleimmersion can create virtual courtrooms where all of the parties, including the judges, can be brought together in a telelinked environment, cutting across continents, jurisdictions, and courts. It also creates the creation of virtual courtrooms, courts of different jurisdictions collaborate. Now, the pandemic has forced the members of the legal profession to accept virtual court proceedings without much resistance. And virtual court hearings will be the normal mode of conducting judicial proceedings in the next future. And if few provisions of the code are flexible enough with the minimum amendments to address these future developments. Two developments will propel the IBC proceedings to migrate to the virtual mode very rapidly before the other courts migrate because two reasons. One, cross-border insolvency matters, which Chandyok mentioned. We did not provide for cross-border in the original draft of the IBC code for the simple reason we didn't have the requisite ecosystems readily. Since it was available, we followed it up very rapidly and everything is ready. And it's only a question of time we can see this amendment will bring in. So when cross-border insolvency matters are brought in, it will require bankruptcy judges of different national jurisdictions to jointly collaborate in whole sittings. A joint hearing requires either court can also question a person who has appeared in the other court or allow one or more persons to speak. The unilateral model law on cross-border insolvency provides effective mechanisms for dealing with cross-border insolvency and to promote amongst other things, the object of cooperation between courts and other competent authorities. The model law provides detailed provisions relating to concurrent proceedings and will be dealt with by courts of different jurisdictions which require direct communication between two courts. It provides for joint hearings between two courts. Secondly, when the provisions related to Part 3 of the code relating to individuals and personal or partnership firms is brought into force, it will be necessary for the individuals to have access to the DRTs, which is the adjudicating authority for personal insolvency, to have online access for the simple reason we have displaced the district court jurisdiction under the Provincial Insolvency Act and the Presidency Towns Insolvency Act, and individuals scattered all over the country should not be denied access to justice. The DRT Act also provides for circuit systems in the district headquarters, and with a minimum amendment, we can always provide for online hearings for individuals, and it can also provide for what Justice Sikri and Chandyok are very passionate about, is providing for online mediation, where the individuals need not have access to legal services at all. So mediation can be online and these issues can be sorted out. So these are the two issues which is going to rapidly push IBC proceedings to the virtual mode. Now, IBC recognizes the asymmetry of information is critical barrier for fair negotiations, for ensuring swiftness of resolution process, and it provides for the regulated information utility that will make available all credit information to all stakeholders in resolving insolvency and bankruptcy. Now, to make this task easier, the government has undertaken a slew of measures, what I would call as the datafication of information. The datafication of information refers to transforming words into data, which unleashes numerous uses and possibilities. It is not merely digitization of information from analog to digital medium, it is much more. To datafy a phenomenon is to put in a quantified format so that it can be tabulated and analyzed and made actionable. In order to capture quantifiable information to datafy, we need to know how to measure and how to record what we measure. This requires the right set of tools. It also necessitates a desire to quantify and record. Both prerequisites of datafication, government has fulfilled, and it's a set in motion the process by amending the SURFACI Act by establishing a central registry which will maintain the record of transactions related to secured assets and central database to integrate records of property registered in various registration systems with the central registry. Now, this includes registration, integration of registration under the Companies Act, Registration Act, Motor Vehicle Act, and etc. And the government can also extend by notification the provisions of Chapter 4 to other types of creditors. Now, so any modification of security interest over any property will have to be entered into this registry. So, and this has become ultimately the government will have to create a public credit records authority which can capture not only information from the banks and financial institutions, other ancillary credit information available outside the banking system from a designated service providers, so that it is made available in a central database for facilitating efficient credit decision making by credit institutions. So this has led to what we call big data. Big data invites lawyers to make fundamental change their approach to the law itself by looking into statistical patterns, predictions, correlations, in addition to the legal rules that perpetually control the outcomes like case law, statute law, procedure rules, etc. New techniques of melding traditional statistics and computer science make it increasingly feasible to analyze large sets of data. These techniques and algorithms developed by statisticians and computer scientists search for patterns in data and has the potential to provide a wealth of useful information if we can develop ways to extract it. The use of data to fortify legal arguments, all of us are aware. It was experimented in the famous US Supreme Court case, Justice Brandeis. Justice Krishna way back in 1974 lamented that we don't have Brandeis briefs on the Indian courts to justify. So IBC places a great faith in the wisdom of the financial creditors and the market forces to decide the outcome of proceedings under the code. For this purpose, big data about the players in the credit market is readily available for the purposes of insolvency and bankruptcy code already to some extent. The ecosystem accompanying the insolvency and bankruptcy code and the implementation of its provisions making use of modern technology and information tools serves as an example of how legal reform will shape future legislations. Not only can the impact of provisions of the code can be measured and calibrated by the government and the parliament, and the impact of decisions of NCLTs, NCLATs be available to make remedial action as and when considered necessary. Now, let me defend the code and the question, has the code digressed from the original stated objective? I said no. The IBC is a legislative response to the long-felt need to reform the credit market in a fast-changing global marketplace. Acts of Parliament are not carved out of stone, which cannot be modified to meet the changing social demands. The government has been sensitive to the difficulties encountered in the implementation of the code. And when difficulties were encountered in its implementation, the government reacted swiftly by amending the code, even by bringing in ordinances. A case in point is amendment which sought to bring some remedy, solace to the flat owners when they are equated with, when they are brought within the ambit of financial creditors. In the process of addressing genuine difficulties of the stakeholders, amendments to the Act may sometimes travel beyond the stated objective, but that is only incidental to keep the Act in tune with the ground realities, to keep it alive. Now, the reason for criticism of the code are threefold. First, the code represents transition from the old legal order to a new legal order, and the tension between the new legal order and the old order is always high at the moment of such transition. We are in the middle of such a transition. Secondly, most of the cases which are clawing the NCLTs and NCLTs for which the code is being unfairly criticized as not being effective are legacy cases which arose before the enactment of the code and were caused by the ills plaguing the credit market prior to the enactment. Since the code has addressed all those concerns, once the backlog is cleared, the credit market will be restored to its original health. Second, the big data about the functioning of the code is readily available. It is possible to measure and evaluate and criticize the effectiveness of this provision level criticism. It is not available for other enactions. Pardon me for saying that no other act contains so much of data to assess the effectiveness of such a legislation. And this is really a great legislation which readily provides you with the standards. And it is thirdly, I will also say, recovery, as Chandra pointed out, is not a benchmark. Recovery legislation, the code is not a recovery legislation. So judging the code on the benchmark of number of cases which have gone into liquidation or where it has to suffer large haircuts is misplayed. That is not the standard by which you have to judge this legislation. Chandra rightly pointed out it is something very different. So all these criticisms are misplaced and the code is working well. And as Chandyok said, everybody is cooperating and everybody is playing a role. But as the code continues its voyage, the ecosystem servicing the code will also gain considerable experience and expertise, which will address many of the shortcomings plaguing the code during the transition from pre-IBC legal order to the post-IBC legal order. See, viewed in this slide, the background, the Insolvency Code is a state-of-art legislation which is drafted to leverage and capitalize on the benefits of modern technology. And it's also a precursor to a new breed of legislation which will adorn the statute in the days to come. And it will facilitate India to emerge a great major restructuring hub of Asia, rivaling Singapore. As Chandyok said, when I was the first person to appear before the committee which cleared the bill, they asked me, where are you going to get these resolution professionals? Up from the sky. I said they will emerge, and they have emerged and they're doing well. And our NCLTs and NCLTs are working overtime with the limited resources and infrastructure they are delivering beyond their means, and they require our support. I'm very sure that we will be able to rival Singapore shortly. And already we have our jewel, Justice Sikri, sitting in the arbitration court, international court in Singapore, adding pride to all the judicial members of the Indian Bar. I congratulate Akriti and Legal Era team for organizing this Insolvency Summit and hope deliberations wield a rich material for government to act upon and enrich the code. Thank you, Dr. Amna. Thank you very much, Chantyok. Thank you, Justice Sikriji. Thank you.